of long-winded speeches that do not address the specific issues. We are willing to say in advance that whatever time you give us, if you give 10 minutes each, we shall accept. If you give 15 minutes each, we will accept.
Professor Githu, which applications have been filed?
Yeah,
how many applications?
The one you directed, my lord, in the morning.
Yes.
Yes. But it is in that application that has been filed by Jindo Matiba and company advocates. That is the application that seeks, on the one hand, that questions how this bench was appointed, and on the second hand, it requires the recusal of this bench.
So for avoidance of doubt, it is one application.
It is one application.
There are three applications.
But there is an earlier application for recusal. And that's why I'm saying we probably can hear both of them together.
Yes?
I'm sorry, my lord, but my lordships and my lady, I just wanted to remind the court of Article 159 of the Constitution. In exercising judicial authority, the courts and tribunals shall be guided by the following principles. And 159(2)b, justice shall not be delayed. So I'm requesting your lordships and my lady to kindly refer to that provisions and let us move forward. Thank you.
My lord, let it come on record that this is the first time in which, on a matter of extreme national importance, we've been given 1 hour to be able to do an application, serve it, and come back to court. We have tried to do the best that we could in terms of complying with those directions. Of course, one of the issues that we could not be able to do is that the written application could not be able to do full justice to the instructions that we've been given and to our case. And therefore, my lord, when Professor Muigai stands senior counsel to say that we need to be gagged on the issue of time, we protest. We shall require sufficient time. This sufficient time is not forever. This sufficient time, at least for purposes of the three presenting the one other application, is 1 hour. It is a list that people deserve in an application of this nature. Secondary issue, my lord, is the issues of consolidation. Those issues of consolidation are as different as UDA can be from Jubilee. And the issue is, for purposes of the difference, the application under Article 165, and we did not hear you talk about the inclusion, because we've had to include. We are earlier complaint in the morning.
I'm sorry to say this.
I have.
Yes, I want to interject. If my learned friend is appealing against your orders, then there is the right one. My lords and my lady take charge.
There is no, I'm responding to what has happened. Let us be fair to each other. And my lord, what I'm saying is this, that for purposes of those applications, the application under Article 165, because in the morning when we raised the issue orally, the questions that was raised, you are raising issues against the Deputy Chief Justice, who is not a party. She is a party now, and we have served her. We took the application on the issues of the constitutional violations regarding the empanelment of this bench. We shall need the court's directions on that issue. And we've gone through the authorities within the short period that we were here. So we are standing on solid grounds. We just need sufficient time to do our business. Issue number 2, my lord, if that application were to succeed, then it would effectively mean, as my learned colleague Mr. Mboya had indicated, that then the issue of recusal of your lordship becomes academic. But if your lordships were to hold that all these serious injustices that the petitioners allege were committed by the Deputy Chief Justice King, then we shall now address you, the issues that concerns you. And I need to add, on the issues of authorities, because now we've been told actions. Well, when we came here, we thought that while we were proceeding in actions, prepare the team in the office, let them prepare authorities to argue on the issue of recusal. When you were given 1 hour, we told them, oh, stop on the issues of recusal, now we are dealing with another thing. So, my lord, we cannot be able to argue, if it is today, we cannot be able to argue, as expected by our client, on the question of recusal. And there is no similarity of issues. Therefore, my lord, I urge you that let us adopt fair procedure. This fair procedure has
is there a specific application for recusal?
There are 2 applications.
Where are they?
At least I know, Gregor will mention one. Yeah. We are actually bringing them, even one of them in number 015 is an application dated, I believe, yesterday, 21st of October. There is another one.
Okay, these are the directions we are looking. We'll deal with the application before us.
Has it been brought?
The application for empanelment of this bench
Can I have application of next year?
perhaps not before you give the directions. With Immortal, she's informing me that she was not aware of directions in the morning, that applications be filed and we come back before you, and now her petition has been integrated in the consolidated petition, that is petition number E013. Therefore, she's not been able to file an application either for recusal or for challenging the empanelment. She was just requesting if she can be served with those applications and the responses, and she did give a time, 1 hour just like the others, to file her single application in the because now she's participating in the proceedings. Council, listen to this and listen to this very carefully. All of us acknowledge the momentous import of the proceedings before us. And all of us are enjoined by the rules of natural justice to do what is right. This bench is not going to be taken round in circles. We will not be taken round in circles. We are here to do justice for the petitioners, justice for the respondents. And anything which is intended to delay these proceedings will not be acceptable because both parties have come to this court under certificate of urgency. Let us be very careful how we argue our matters. We want everybody before us to get justice. That justice will not be possible if every advocate who stands up wants to take the cause in cycle. We will not allow that. I'm making final directions on this matter. The matter which we are dealing with is an application dated 22nd of October 2024 by Githu, Matiba and Company Advocates. It seeks orders under Rule 3 of the Constitution. We are dealing with the issue of empanelment. And then after that, we'll look at ruling for the way forward. So let us proceed. Let us be courteous to each other. Let us be courteous to the parties before us. Parties before us are very okay, but let's not be a theater by advocates to derail the process. I beg you. on the issue of time allocation, Judge Moreno will give the final issue directions on time.
This is how we proceed. The applicants will have 20 minutes to argue their application. Any party in support of that application will have 5 minutes to support that application. And the respondents will have 7 minutes each to respond to the application, as well as any other party which will want to respond to the application.
We are aware that there could be parties who, for the good reasons given, may not have filed anything. But we also appraise ourselves for the fact that the issue before the court is an issue of law. Therefore, we'll give you time to make submissions on the issue.
May I please, the clients I and my colleagues represent, the deputy president, is the subject of the removal of the subject of his pleas to this honorable court. Him not. The application for the constitutional bench is made in E015, as my friends given, so that effectively the subject matter of the removal is being given only 5 minutes. I plead with you, give us 10 minutes.
How long do you need?
10 minutes. Out of 6.
You have 10 minutes. You have 10 minutes.
Yes. Dr. Kamina, we please not audible.
Oh, I'm sorry, I'll speak now. Yes. I received instructions yesterday from Githu here that I come and make an application that Githu would like to be joined this meeting. We all know Githu here. We can't pretend that we don't know and we know the role Githu here has played in advancing the jurisprudence of the Christianity and the rule of law in this country. So I urge you respectfully that you place my name on record. Secondly, I would like also to place my name on record in my own right as an elder at the bar and one who has seen for a number of things which I may not be able to say if I'm representing the position.
That is okay. We have done that.
Thank you very much. May I then comment on one small thing? My Lord, the country is not crisis. There's a constitutional crisis. There is a national crisis. And our coming to this court is like commencing or opening an opportunity for healing in the country. And if I may say so, with tremendous respect, with tremendous respect, this is not a matter where you should be allocating some 5 minutes, 10 minutes, 20 minutes. No, that is not suitable. Let these lawyers talk. They are part of the healing process to the 50 million of Kenyans. A number of them are glued now to radios and TVs, trying to hear what is being said in this court. And for this honorable court to come and say that my ever friend, Mr. Muigai, will only have 10 minutes, will have no 5 minutes.
Mr. Muigai asked for 10 minutes and we allowed him to have 10 minutes.
He said so because he was under coercion.
What?
I am taking the trouble to read this constitution of Kenya. I have taken the trouble to read constitutions of other countries. In fact, the way things stand at the moment, the constitution law is evolving in such a manner that it's no longer confined only to Kenya. We can have a concept of international constitutional law. And if you read that law, including the American law, which I've taken the trouble to read, and which I've had access to it for many years.
Dr. Kamina, we made proposals and we gave directions. Apparently, you are not satisfied. What is your version? What would you want us? You want to give everybody how much time?
My Lord, forget about the concept of time. Forget, where are we heading for? What are we heading for?
So, yeah.
Yeah, we want the country to wake up and to revive and to give the life to the country. The country is Kenya, if you don't know what I'm talking about. Let the lawyers say what they want to say. This should be part of the healing process of the whole country.
Dr. Sakamina, I ask you.
Yes.
We have given directions on time allocation.
Your hands are not tied with respect.
Okay, tell us, just tell us, in your view, how much time do you want us to allocate parties? What
I'm saying to the tremendous respect, my Lord, we talk about time in civil matters and so on. But we are dealing here with the issue of impeachment. Issue of impeachment of the deputy president. It's not a small matter at all. It's a matter that is starting the whole nation. It has paralyzed the nation.
We have heard you, Dr. Kamina.
Let Paul Ruto be given as much time as he wants. Let the professor be given as much time as he wants. Let the Honorable Attorney General be given as much time as he wants. That is the healing process. And from this court, we shall all march forward with confidence. If I may quote Mutaje Makinata, before and buried the Matako New. Let us forget about corporate time. Where are we going?
My Lord,
where are we going with
Prince Dr. Kamino?
With respect, will you sit down? Kamino is talking. Will you sit down? I am talking.
Under the rules of this court, senior counsel has preference, speaks first before any other person except the Attorney General. So if you would please sit down. I, as senior counsel.
I will not speak down. We are practicing law. You're still doing breastfeeding.
That is also.
My Lord, what I'm saying, what I'm saying to you, my Lord, we need a healing process, and this court is going to provide that healing process. Let the lawyers say what they want to say. What are we heading for? Let us not have some people calling themselves professor or senior counsel titles that don't